Auditorium and take your seats. Just to reiterate that in your folders, in the blue folders, there is an evaluation form, and I really do solicit your comments on how, when I start doing this again next spring, we can make it even better, regardless of whether we're talking about creature comforts or things that you think would be appropriate for our program. So I really do ask for your comments to help us make this better each year. This morning, we'll be having our fourth panel of the conference, the first of the morning, and there is probably no more topical issue than how alleged terrorists are being interrogated for purposes of intelligence gathering. And so we would have been remiss if we had not included that issue for one of our panel topics. I need to mention that one of the panelists, Marty Lederman, for this morning's panel, got canceled out of a flight late last night in Washington, D.C. He offered to drive all the way down to arrive at 4 o'clock this morning. We thought that was a safety problem, and we didn't want him to do it. So Marty was not able to get here, not because he didn't want to, but simply because flights get canceled, and that's been a problem, as most of you know, all over the country the last day or so. But Professor Bobby Chesney, who is my good friend and colleague, professional colleague from Wake Forest, has told me that he and the rest of his panelists are well up to the task. So Bobby, without further ado, let me turn it over to you.
Thanks very much, Scott. Good morning, everybody. Let's see if we can wake everyone up. Actually, bear with me.
CG just confirmed that McCarthy is looking for an engineer for Fein that can arm the nukes. You're wasting time talking to me, Jack. You're holding something back. The machine doesn't lie. It must be broken because I told you everything I know. It's an isopentanol. It's a neuroinflammatory designed to induce pain. All you have to do to stop me from using it is tell me how to find McCarthy. Your guess is as good as mine. 2 cc's. You will experience a pain I can't even describe. At 8 cc's, I run the risk of inducing a heart attack. Right here. Make no mistake about it. I will go there if I have to. Please. Just tell me what I need to know. Please. I don't want to hurt you. Be sure about that, Jack. Please, Craig. Just tell me what I need to know.
Just tell me what I need to know. Of course, 24, and I hope I didn't spoil the season for anybody who's following along the show, but Jack does torture his brother. That was his brother in that scene. The scene you just saw, of course, is from the immensely popular television show 24, and that was Jack Bauer engaging in something that happens on the show fairly frequently, which is the torture scene. Jack remarkably often has occasion to use coercion, maximum coercion possible, type of coercion that doesn't actually present any kind of close definitional call on the legal issues and legal frameworks that we like to talk about and that we will be talking about later today. In 24, the need for torture is pressing. There is a ticking, it's always the veritable ticking time bomb scenario. Generally speaking, the torture is in fact successful from the point of view of obtaining the information, and almost invariably the detainee really does have the information and eventually does give up accurate, actionable intelligence that averts the next next possible negative development in the plot. Of course, reality is rarely, if ever, anything remotely like this from both directions. It's rarely, if ever, truly the ticking time bomb scenario. It's rarely, if ever, as clear that the person being subjected to coercion certainly has the information that you want, and it's rarely the case, perhaps, that it works quite as effectively as it does in 24. It's also probably rarely the case that measures as obvious and overt and extreme as the Jack Bauer method are employed as well, but then again, I'm not really in a position to speak to that. So 24, in a way, distorts the national debate. It's immensely influential. Jane Mayer's recent New Yorker article talked about the questions that the commandant in West Point had about the impact of shows like 24 on the impressions and beliefs of the cadets coming in, these assumptions they had about what works and what is normal, what's considered typical to resort to. And so it's becoming part of our social or popular cultural life. And of course, it's becoming that because it's a pressing practical issue from a variety of perspectives in the real world. Over the years since 9/11, of course, we've come to appreciate that our conflict with Takfiri extremists is in significant part a conflict that requires more than in the ordinary case intelligence. And some have described it as an intelligence war, an intelligence conflict. And in many respects that's correct because it really turns on information that is unusually hard to get, as Ben Powell was describing last night. It's not a question of intentions, it's a question of who and where. Where are they? Very different from the Cold War framework. One source of information, of course, that matters perhaps more than most others is the information that might be obtainable from those whom we do detain or whom our allies detain, whom we or they believe to be members of Al-Qaeda or an associated group. And that's a euphemism we use, the associated group, to refer to the fact that the borders or the outlines of the category of persons who are the enemy in this conflict, it's not as easy to describe as in a conventional conflict because of the very nature of the network entity that we're dealing with. So the information those persons might be able to provide is of pressing concern. How far can we go to obtain the information? That's a legal question. It's a moral question. It's a question of practicalities, what works and what doesn't, what is the empirical evidence of varying approaches actually producing reliable, actionable information. It could be a question of professional ethics, depending on the profession of the persons involved. We've heard a lot of discussion about that. It could be a question of your religious convictions as an individual. You have to think about it through all of these frameworks. What are the restraints? What are the considerations that beyond the legal restraints might matter? We hardly have enough time this morning, even with the absence of one of our panelists. We don't begin to have enough time to even skim the surface of each of those dimensions of the problem, so we won't try to do that. What we will do is we'll narrow the focus to the legal piece of the puzzle, and even within that we'll be rather cursory. And we'll talk a lot about something that doesn't get talked about in these legal conferences all that often, which is the practical side of it, this question of what works and what doesn't. When you have people on both sides of the debate, it's often the case as they speak about the legal issues that you detect a premise, an unspoken premise, that coercion does generally work and does generally provide useful information, or the contrary premise that it clearly does not work and it's a big waste of time. It's helpful to know as much as we can know about what actually is true about varying methods. As to the legal framework, in Marty's, I was going to rely on Marty to discuss a lot of the legal framework. In his absence, I'm going to begin to do some of that right now. I'll lay out a few of the mileposts that I think you'll find relevant to the discussion. And for those of us in the room who follow these issues rather closely, you'll appreciate that I'm glossing over oceans of important nuance here. Let me begin out at the international law plane, go out to the broadest level, it seems most appropriate to begin with the Convention Against Torture. Let's talk about CAT very briefly, and I'll just relay to you quickly what this treaty provides. I should add quickly, CAT is what we call a non-self-executing treaty in domestic law terms, which means that its provisions, we are bound to them on the international plane. Most judges would say that because it's non-self-executing, it does not directly operate as a rule of decision in litigation unless and until Congress has enacted the provision and issue into statute, which in most respects has happened with CAT, actually, or at least arguably has happened. The two provisions I want to highlight are CAT Article 2, which provides that every state, or each state, shall take effective legislative, administrative, judicial, and other measures to prevent acts of torture in any territory under its jurisdiction. Focus on that clause, any territory under its jurisdiction. There's a bit of a geographic restraint there, and there's a debate about where that obligation extends. When you have places like Guantanamo where the question of sovereignty and territorial control is disputed, you run into questions about the scope of the CAT Article 2 obligation. CAT Article 2 goes on to note, and this is also extremely important, there are no exceptional circumstances whatsoever, whether a state of war or threat of war, internal political instability, or any other public emergency that can be invoked as a justification for torture. The torture ban is as absolute as can be. What's not absolute is where the line is between torture and other categories. Speaking of other categories, let me note CAT Article 16. Each state party shall undertake to prevent in any territory under its jurisdiction other acts of cruel, inhuman, or degrading treatment or punishment which do not amount to torture, as defined in Article 1, when such acts are committed by or at the instigation of or with the consent and acquiescence of public official or other person acting in an official capacity. So, the CAT framework. What about the fact that this is, for domestic law purposes, most certainly a state of armed conflict, at least insofar as al-Qaeda and the Taliban are concerned? What then? Lex Specialis tells us, as most would say, not everyone agrees exactly on how this works, but in time of armed conflict, the interaction of international human rights law, as I've just described it, with the law of war is to some extent impacted by the scenario in which the law of war provision on point is more specific. In that case, at least some would say that the proper interpretation is to take the human rights law provision and conform it to the level of permissibility established in the law of armed conflict. Well, what does the law of armed conflict have to say on this point? The most pertinent provision to highlight would be the Geneva Convention, Third, Prisoner of War Convention, GPW Article 3, or so-called Common Article 3. Common Article 3 has a number of provisions, number of elements discussing what can and cannot be done, or really what cannot be done with respect to detainees. Violence to life in person, in particular murder of all kinds, mutilation, cruel treatment, and torture are forbidden there. So as far as torture is concerned, war or no war, between the no war exception language in CAT Article 2 and GPW Common Article 3, there's no question torture is off the table. Again, the definitional concern, well, what does the GPW have to say about the lesser category of cruel, inhuman, or degrading treatment? It includes outrages upon personal dignity, in particular humiliating or degrading treatment. And I think let's just pause and I'll be quiet for a second and think to yourself, sorry, I'm getting into my law classroom mode. I want you all to think to yourself, I'm not going to call on you, but what do you understand outrages upon personal dignity to mean? What would you consider an outrage upon the personal dignity of a U.S. soldier who's in enemy custody? What would you consider to be an humiliating treatment of that person? Think about the recent Iranian detentions of the British sailors and Marines. At any point, from what we understand, were they subjected to outrages upon their personal dignity? Were they humiliated? Were they treated degradingly? What do these standards mean to you? And do you think that if we took a poll around the room, all of us being reasonable people, we'd have more or less consistent agreement? Moving beyond the international plane, there's the constitutional consideration. Substantive due process shocks the conscience, right? It's a concept familiar to us from the point of view of, for example, the way that police may interact with citizens. What conduct is appropriate, what is not, as a constitutional matter when the U.S. government is acting on someone who has due process rights. Well, that's the trick here, right? If it's a U.S. citizen detainee in this conflict, clearly Fifth Amendment standards are going to come into play. If it's a non-citizen within the U.S., arguably so. If it's a non-citizen outside the United States, what then? And what then if it's Guantanamo, where, again, the territorial status is obviously much in dispute, and there's much debate about whether and to what extent constitutional rights extend to that location. Most recently, the D.C. Circuit in Boumediene panel said no. There is indications to the contrary, perhaps, depending on how you read the Supreme Court's Rasool decision. It remains to be seen what the final answer there will be. Moving beyond that, going down to the statutory level, you have any number of considerations. I'm not going to go into all of them in any detail, but simple prohibitions on assault, UCMJ prohibitions on assault, the Army Field Manual. Actually, as I mention these things, it becomes appropriate to sort of switch back to what I'd originally intended to talk briefly about on this subject, which is the most recent developments that you should bear in mind on this heading. Let's start perhaps with spring of '02. There's been tremendous internal debate in the administration about precisely what the status under the Geneva Conventions of the conflict with al-Qaeda is. Is this a common Article II conflict, a traditional interstate armed conflict? Is this a common Article III armed conflict, or is it perhaps in a category that is in between and thus uncovered by the Geneva framework and covered only then by customary international law? Ultimately, the President renders what might be described as a split decision. He concludes, against the advice of the Office of Legal Counsel, he concludes that the Taliban can, and for this purpose would be treated as the government of Afghanistan, rendering the conflict between the United States and the Taliban a common Article II conflict. But then he goes on to say that for a variety of reasons, Taliban detainees do not qualify. Collectively, they fail to qualify for POW status under the GPW Article 4 analysis, and then draws a line and says we're going to separately analyze the al-Qaeda United States conflict. That conflict is not one state party to the conventions against another. By definition, it's not that. It's not, therefore, a common Article II conflict. Is it then a common Article III conflict, as many would say, and as ultimately the Supreme Court did say? Concluded no, this falls in the gaps. Common Article III on this construction was meant to apply to the Civil War scenario, and this is a global or transnational conflict, not between states, but geographically not confined to the territory of one state, and therefore it falls in the gaps. So for a time, the governing executive framework was, at least as to al-Qaeda, you're resorting back to customary international law, or the customary law of armed conflict. The Geneva Conventions had no application. Rolling ahead, next perhaps most significant development to note is the McCain Amendment to the Detainee Treatment Act. As we all will recall, the McCain Amendment required compliance with Army Field Manual on interrogation standards as to detainees in DOD custody. As we all know, not all detainees, at that time at least, were in DOD custody, including perhaps the most high value of the detainees. As to high value detainees, though, the McCain Amendment did have some impact because it did go on to say that regardless of which agency's custody you're in, if you're in U.S. government custody, cruel, inhuman, or degrading treatment is forbidden. At the same time, there was no criminal penalty attached, and there was some question about what exactly the practical significance of this prohibition would be. Rolling ahead to the Hamdan decision this previous summer, summer '06, Hamdan is important in many ways. Perhaps, I think in my view, by far the most important aspect of the opinion was the determination, and there are some questions about how exactly to read the opinion on this point, but most observers have taken it to be a holding that common Article III applies to the conflict with al-Qaeda, contrary to what the President had determined early on. And that's an interesting holding in innumerable respects, but for practical purposes, the most important aspect of it is that it brings into play the War Crimes Act, the federal statute that criminalizes various war crimes, which at that time, as written, incorporated lock, stock, and barrel common Article III, including the personal dignity, humiliating treatment, and other standards that I asked you to think about a moment ago. At that point, the specter of criminal prosecution arose for other government agencies who may be involved in the detention and interrogation of prisoners who had been proceeding on the assumption that the common Article III standards were not a consideration to be concerned about. In the wake of this decision, of course, we get the Military Commissions Act, which among many, many, many other things, which we'll be hearing about all day today, included amendments to the War Crimes Act replacing the blanket incorporation of Common Article 3, lock, stock, and barrel, as a prosecutable offense when violated, replacing that with the seriatim description of specific actions that would be prosecutable. So some have construed this as an attempt to narrow the War Crimes Act to prevent prosecution in scenarios such as waterboarding, long-time standing, extreme stress positions, various other things that some have called, Mark Bowden's described them as torture light. Others say, no, what's going on here is an attempt to address the problem I was highlighting a moment ago when I asked you guys to think about what outrages upon personal dignity, what humiliation means, to address the uncertainty and the reality that many reasonable people, and especially once you go into the international community, a variety of perspectives will be out there about what this conduct could mean. And so the other way of looking at the amendments is to say that it's meant to provide more certainty to our government employees involved in all of this. Now, all of this is also taking place, of course, against the backdrop of an ongoing string of revelations, in some instances allegations, in some instances there's questions about what happened, some instances there's not, about the treatment of detainees, whether in CIA custody, Guantanamo, Iraq, various other locations. I don't need to recite the litany. There's a familiar litany of events the past 5 years that have taken the issue of torture and, perhaps more usefully said, coercive interrogation up to the front burner of the national debate. So all this is going on, and it's shifting the political framework and the social framework against which we have to think about these legal issues, and it's driving some of these legal changes. And there are other things happening as well, things that are, I think, equally important but often overlooked, and we're going to hear about them a lot this morning. The ongoing trend of privatization of functions relating to security, which has a significant impact, I would say, on interrogation as much as any other function in the security realm. The privatization of security functions, including many elements in some instances relating to interrogation. After all, the things I've just said, you should have a sense that the legal framework here is somewhat nebulous, although not entirely nebulous, and complicated. How much more so when we get beyond government employees and get to government contractors? Some of these pieces don't work. They don't match up to that scenario. Some do. Some might, and we have to figure out how they do. So in light of all these considerations I've put out on the table, we're very fortunate to have an extremely talented group of experts to discuss them with us. We're going to begin with Dr. Robert Fein, who is a forensic psychologist specializing in threat assessment and the prevention of targeted violence. And I'll note briefly that I could go on probably the entire time describing the three panelists' accomplishments. So trust me when I say that I'm giving you only just a slight taste of what they've done. In pertinent part, I want to highlight that Dr. Fein is a member of the Intelligence Science Board, and in that capacity, he chairs the ISB's study on educing information. This study has resulted thus far in a phase 1 report that's been issued recently. It's a book version, I think that's a fair way to describe it, a book version of the report. It's published by the National Defense Intelligence College Press, has come out. I have it here. They have them out on the table. They may all be gone by now, but if they're not gone, you should sneak out and grab one before they're gone. There are many of them actually right here in the front, so when we're done here, I'd highly recommend grabbing one of these. It's fascinating, and we're going to hear a little bit about that this morning. His work with the intelligence community on this issue continues. He's deeply involved in trying to find a way forward that's consistent with what actually works in light of empirical evidence. Next, Professor Laura Dickinson, who ordinarily can be found up at University of Connecticut School of Law, but if you need to find her this year, you need to go to Princeton because she's serving as a fellow in the program on law and public affairs at Princeton. Laura has written extensively on a variety of topics, including international human rights law, but most pertinently to our current topic, she's been writing a great deal about the privatization phenomenon, including in particular how it intersects with the human rights framework. And then last but definitely not least, Mr. Jim Candelmo, Assistant United States Attorney, Eastern District of New York, right here in this part of the country. He's also the Anti-Terrorism Coordinator since 2001 for the district. Jim's a 15-year DOJ veteran with extensive trial experience and, more pertinently, extensive national security issue experience. Most recently, Jim successfully prosecuted David Pissarro, a contractor working for the CIA who was involved in a detainee abuse incident that resulted in the death of the detainee in Afghanistan. This was a landmark prosecution, so far as I know, the only one of its kind, successfully convicted, and I believe Mr. Pissarro just got his sentence just over 8 years. Is that right? It's a fascinating case. The range of issues that were litigated there, from public authority defenses to just the practical consideration of how in the world do you truly litigate a case where the underlying events happened in a war zone half a world away. And with that, I'll stop talking and turn it over to Dr. Fein.
Good morning. My name is Robert Fein. I'm a forensic psychologist. As I was preparing to participate in this conference, I had the opportunity to talk with an old friend who just got back from a trip around the world. And my friend told me about a rather remarkable experience that she had. She went to a market in a country very far away, and in the middle of the market was a sign saying "brains for sale," and underneath that was a sign saying "law school student brains for sale," $4.29 an ounce. Next to that was a sign saying "practicing attorney brains for sale," $37.61 an ounce. Next to that was a sign saying "law school professor brains for sale," $71.44 an ounce. And next to that was a sign saying "forensic psychologist brains for sale," $711.12 an ounce. And my friend, being economically and mathematically interested, went to the head of the market and said, "How do you explain this price discrepancy? Student brains, relatively inexpensive; practicing attorney brains, also relatively inexpensive; law professor brains, relatively inexpensive; but forensic psychologist brains, really very expensive." And the head of the market turned to her and said, "Do you realize how many forensic psychologists we have to catch to get an ounce of brains?" So I offer that as a preface to my comments this morning. I have the privilege of serving on the Intelligence Science Board, which is an advisory group appointed by the Director of National Intelligence. The board is fortunate in that there are two attorneys on the board, one Professor Philip Hyman of Harvard Law School, former Deputy Attorney General, and also recently invited Professor Chesney. The mission of the Intelligence Science Board is to provide the overall intelligence community with outside expert advice and unconventional thinking, early notice of advances in science and technology, insight into new applications of existing technology, and special studies that require skills or organizational approaches not resonant within the intelligence community. A number of years ago, there was a study done of the average IQ of members of the Intelligence Science Board. It was seen to be much too high, so they reached out and they invited me to join just to level it off a little bit and come more in context with norms. So about 4 years ago, I joined the Intelligence Science Board. At that time, I had the privilege of being a consultant to the Department of Defense's Criminal Investigation Task Force, which was set up pursuant to the President's Executive Order of November 13th, 2001, which directed the Secretary of Defense to set in process ways for certain people, Al-Qaeda related or Taliban related, who came into the custody of the U.S., who are not U.S. citizens, to come before various tribunals. And as part of that, the Secretary of Defense established the Criminal Investigation Task Force, which was a purple task force under the auspices of the Secretary of the Army. For historians, why? Because Nuremberg trials occurred under the auspices of the Secretary of the Army. And the Criminal Investigation Task Force had a whole bunch of investigators from various military law enforcement organizations and members of the various services, the task of which was to do investigations to gather information, evidence that might ultimately go to prosecutors and might ultimately result in commissions. And it quickly became apparent that of the, at that point in mid-2002, early 2003, of the more than 600 men at Guantanamo, not all of them were going to be going to commissions, and there was a whole question about how do we think about all of these people. So a number of us were invited to review a whole bunch of files to try to think about quote, risk assessment. How does one, for someone who's in custody at Guantanamo, how might one think more clearly about the risk that such a person might present if released? I say that because it gave me the opportunity to review many, many files of men at Guantanamo and to read many, many interrogations. And I came away from the start of that work thinking about the question of how might we do better in the area of interrogation. And I went to my colleagues on the Intelligence Science Board, and I said, do we know what we know about interrogation? What do we know about the content of interrogation, about doing this in as effective a way as possible? And I was encouraged to talk with members, senior members of the intelligence community to see what was known about this activity that the U.S. government actually had not been involved with in any large scale, certainly, since about the Vietnam era. So I went with the Executive Secretary of the Intelligence Science Board to a number of leaders of intelligence agencies and said, you know, can we talk about what we know, what's known scientifically, what's your training, and fundamentally, leaders of a number of intelligence agencies said, we need to learn a whole lot more here. And a number of agencies said, oh, it's the other guys over there who really know. They're the experts. So we went to the other guys, and they would say, no, it's the other guys over there who really have the expertise. And finally, we went to one meeting with an intelligence agency where there was a very able attorney, mid-career person who had the, I thought, the courage to speak truth to power, who basically said, listen, there's nobody in the U.S. government who really knows a whole lot about this right now, no organization. That led three organizations in the intelligence community, DIA, ITIC, the Intelligence Technology Innovation Center, and CIFA, Counterintelligence Field Activity, to sponsor the Intelligence Science Board doing a study on, in effect, the future of interrogation. And the National Defense Intelligence College, as Professor Chesney said, just published the Phase 1 report, Adducing Information, which is our effort to ask and try to respond to the question, what is known scientifically about interrogation right now, and how might we put forward some ideas that might guide thinking, encourage better thinking in the future. And there are copies of the report, a couple here, there's a bunch at the table. There are enough for anybody here who wants it. This is an unclassified study, published, available. It's on the web, and as some of you know, the way the world works. Before I actually saw even the proofs of it, the Federation of American Scientists Secrecy Project had it, put it out on the web in a PDF form, the actual document. It's just marvelous the way the world works. It's an unclassified document, so no great harm done, but it's also available on the web. So we started this study in 2003, 2004 with several premises, and here they are for your consideration. First, for the foreseeable future, the U.S. government will need to obtain information from sources under U.S. control who are thought to possess information critical to national security and who present varying degrees of cooperativeness. Second, U.S. efforts to procure information from uncooperative sources will be most effective if they are based on sound knowledge of social and behavioral science. And third, there are major overt and hidden costs to getting these efforts wrong and tangible benefits to national security to getting them right. Three assumptions. One of the things at the beginning we had to think carefully about was what to call what we were doing, because as some of you may know, interrogation has certain technical meanings in certain parts of the government. In the military, there's clear doctrinal differences between elicitation, debriefing, and interrogation. but in some ways more important, interrogation has a whole range of stereotypes that are out there that I think inhibit sometimes rational and clear thinking. This was borne out to me when I read a New York Times article in May 2005. It was about Newsweek investigative reporter Michael Isikoff, and the New York Times writer used these words, quote, "An investigative reporter for the Wall Street Journal who's friendly with Mr. Isikoff, but has also competed with him for stories, described him succinctly. Mike will pull your fingernails out over coffee discussing lawn care. He is just a born interrogator." I read that in the New York Times and I said, you know, this is not a great word if we're trying to have some discussion about the future. So we went to the thesaurus and we found the word educing, E-D-U-C-I-N-G, meaning to pull out, to draw out. And so we talked about educing information from persons in custody who may have information critical to national security. I should tell you, when you type, if you type the word eduction, it will get underlined if you use word because it will want you to say education. And when we offered to various organizations in the intelligence community a number of briefings about our study on educing information, there was a wonderful memo that came out to people saying, come to the briefing in the ISB study on reducing information, which we figured would have drawn thousands of people there simply because the person typing it could not believe that there was a word like educing information. So what did we do? We first reviewed anything known about the science of interrogation. What studies were there in the literature that spoke either directly or indirectly to these questions? We visited training centers, U.S. government training centers, those sponsored by DIA. We visited Fort Huachuca, the Army, now Center of Excellence for Human Intelligence training. We visited Dam Neck, the Marine Training Center. We visited Quantico, FBI training. We visited FLETC, the Federal Law Enforcement Training Center. We talked to people there about how they approach this question, what were they teaching, what were their understandings. We talked with interrogators from all over the government, finding to our pleasure that there really are a number of experienced, thoughtful, decent people who have a passion for interacting with people in a way that might get information critical to national security and enormous expertise, though interestingly, many of them are quite isolated in their organizations. And when we had a number of meetings where we invited experts to come together, they just had an absolutely great time, and it was a kind of wake-up call. Holy cow, I'd heard about you, I'd never had a chance to meet you, because the organizational silos often make it very hard for people to talk with each other. We worked with the Joint Military Intelligence College, now the National Defense Intelligence College, and actually, as we speak, there are 4 students there, 2 from the Army, 2 from the Air Force, who are doing master's dissertations on the future of educing information, seeing this as a research area from which we all might learn. We worked with Professor Hyman and Professor David Rosenberg at Harvard Law School and some terrific Harvard Law School students to review what is known about law enforcement interrogation. Police have been doing interrogations for a couple 100 million years, it appears, and we want to know scientifically what's known about that, what's the research on that. We looked at a number of foreign countries. Let me briefly summarize what we've learned, and by starting with a little bit of history on this that I think adds an important context. In the Korean War, a number of U.S. Military persons were taken into custody and gave these outrageous confessions to things they never did, which were put on television. The Chinese got those, confessing to germ warfare, confessing to things they never did. When the Korean conflict concluded and these men were released in the early 1950s, there was a very vigorous national debate. Were these soldiers, quote, brainwashed, or were they traitors? Brainwashing was a concept first introduced to the American public in Reader's Digest in 1951 by a man named E.J. Hunter. And the federal government responded by funding a number of studies about interrogation. Generally unclassified studies available for anybody to read. My favorite actually is published in 1956 in the American Medical Association Archives of Neurology and Psychiatry, titled Communist Interrogation and Indoctrination of Enemies of the States. 76-page article detailing Soviet interrogation and Communist Chinese interrogation. Finding was, this ain't science. This is not Pavlov on steroids. This is Russian police state techniques the Soviets used and refined, and the Chinese took group process, group pressure, and education and modified it, but this is not science. These studies, and there were maybe 40 or 50 of them, were done from a defensive perspective. We need to learn about what adversaries might do to U.S. military people if taken in custody so we can prepare them. And it led to some very impressive and innovative work that ultimately resulted in programs like SEER, Survival, Evasion, Resistance, Escape programs, where U.S. military persons and others are trained how to respond if these kinds of techniques are applied to them. At the same time, in the 1950s, the brand new and fledgling CIA started some offensive research on offensive interrogation, work using various drugs, including LSD, sensory deprivation, hypnosis, alcohol, and a number of other things. That work came to public attention in the 1960s, led to congressional hearings in the early 1970s, was seen as having crossed a number of ethical and other lines, resulted in a lot of publicity. One of the programs that came to public attention was known as the MK Ultra program. The net result of this was that we could not find any government-funded research in the last 40-plus years on interrogation. So in effect, when U.S. Government persons, be they official in the military or other government agencies or contractors, in the post-9/11 world, were placed in a situation of, there may be attacks coming, we have people in custody, how might we interact with them to get information? The U.S. government had not funded, as far as we could find, any studies that spoke to that question. There were, though, a lot of studies that we found from the 1970s, 80s, and 90s that spoke indirectly to this question. The whole field of consumer research, of marketing, there were a lot of studies on influence, on changing people. Why do we buy the toothpaste we buy? Why have markets developed for deodorant? So there's a lot of funding around the question of how do you get people to change their attitudes and change their behaviors. We couldn't find that there'd been any effort to take that kind of social science research into this area of changing attitudes, changing behaviors, interacting with people who might have information critical to national security. We did find, as I said, that there were and are some wonderful people with terrific experience and now great expertise, but generally there are several in a number of agencies, and they generally don't work together very much. So one of the things we did was we tried to look at what's known in the social science literature. There's a chapter on that in the report, in the book. We also tried to say what's known about detecting deception, both from a behavioral perspective, persons interacting, and also from a more mechanical, the machines. And I'll tell you the most robust finding in the literature on behavioral detection deception, which is people who can, who believe they can tell you if someone's lying, generally are far more certain about their belief than in reality they can do it. That's the one consistent finding across the studies. Now, who of course have been the subject of these studies, of the 120 major studies on detection deception? College students, because they're the people who can be studied more easily. Second have been minor kind of criminals. We could not find one published study on detection deception where translators were used, for example. At the same time, the U.S. government is telling wonderful people, reservists, from firefighters, police officers, teachers from Toledo, Ohio, who have been mobilized and down in Guantanamo and told to interact with people from other cultures and organizations. You got to detect whether they're lying. We looked at mechanical detection and deception. You saw the truth serum stuff. Well, the truth serum, quote, truth serum, is actually doesn't get the truth and is not a serum. The Michigan State Police did a quite wonderful study in 1951 where they tested a number of barbiturates versus alcohol. They had a number of armed robbers who sort of agreed to talk with them, and their conclusion was that it was cheaper, safer, and more effective to get a subject drunk than to stick these drugs into them if you're trying to get the truth. That finding still tends to hold right now. So there are wonderful fantasies about truth serum, but to put it in a more careful way, if there is truth serum, it is such a closely held secret that no one knows about it, as far as we can tell. We looked at law enforcement approaches to this, as many of you may know, and as Professor Chesney suggested implicitly. How do most law enforcement officers learn about interrogation these days? Television. Andy Sipowicz, 24. And we looked at, and we talked to a number of federal agencies and law enforcement agencies, said we welcome any help to learn about this. So we then included a couple of chapters to get people to think a little bit more. We asked a very experienced interrogator to look at the written in 1963, declassified in 1997, Kubark counterintelligence interrogation manual written by the CIA, look at it through 21st century eyes. Colonel Kleiman wrote a very interesting 2 essays on that in the book. We looked at some people who are negotiation professors, asked them, negotiation, any interaction between two people might be seen as a negotiation, might be concepts in negotiation, particularly about interests of a person, of sources of power that might be useful. And we tried to look at what a research agenda might be. Over the last year, we've been briefing this report we've been finding throughout the intelligence community, sending drafts, talking with people, encouraging leaders in the intelligence community to think about where to go from here. I should add, because I see some friends from the military here who may already know this, when we had the privilege of talking with wonderful people at Fort Huachuca who were at that point rewriting the Army manual, rewriting Manual 3452 to the current manual. We sat down with them, and there was a lot of attention, publicity to the, quote, 17 techniques in the Army Field Manual, discussions about what Secretary Rumsfeld and others had agreed to. And we said, where did these 17 techniques come from? And the people rewriting the manual very straightly said, well, we think they got put in about 60 years ago, but no one knows what the rationale was. We actually found some Korean War documents that psychological approaches to interrogation that have the fundamental core of what's in the current Army Field Manual. We said, has there any research been done on them? And they said, no, that would be great. It'd be really terrific to do some research on these men. I pointed out because people believe, and I actually think there's a lot of solid stuff in the Army Field Manual, but it is the law of the land for the military, and there's been no research done on it in 50, 60, 70 years. That to me is pretty astounding in a kind of way. So what we've been doing has been presenting what we've been learning to leaders in the intelligence community, and I'll close with asking you to think about this question. Suppose several months from now, information from multiple sources comes to light that there is a person in Nebraska, let's say a non-U.S. person in Nebraska, who has information about a non-imminent but developing plan to smuggle a nuclear device into Detroit and blow it up. First of all, who should be thinking about deciding what should happen to that person? If the interest is preventing attack, intelligence, getting information, and if it's decided to take that person into custody, how should that person be taken into custody? Arrested, therefore arraigned, given an attorney, material witness, some immigration type way, declared enemy combatant, another government agency taking them to some unknown place. If they're taken into custody, how might it be structured so that the best, most thoughtful people involved with interrogation, knowledgeable, interact with this person in order to get the information? How should that happen? How is it structured? What organizations need to be developed? Some countries in the world have small cadres of professional interrogators, career line people who do that. Our country so far has not gone that route. But these are the questions to the future. Questions that lawyers might think about, but also questions that policymakers and others, if we're going to need a capacity to, consistent with the law, consistent with what appears to be appropriate, interact with persons who may have information critical to national security, how should the U.S. government develop that capacity with the goal of getting information that can help keep people safe? We are continuing to work on this project in phase 2. I welcome any thoughts, comments that anybody have as we continue our work, and I appreciate the chance to talk with you. Thank you very much.
Thank you so much, Bobby and Scott, for inviting me to participate in this conference. When we think about the appropriate limits on the interrogation practices that are used to question detainees and how to hold interrogators accountable when they cross the line, we often assume that interrogators are governmental employees, uniformed troops or from the CIA. But in many cases that's not so, and they are private contractors. So this raises some very, very important questions. And just to take a very well-known example, at Abu Ghraib prison, contractors were there on the ground committing abuses directly. One contractor interrogator reportedly suffocated a detainee for several minutes during questioning. Another one threw a detainee off a truck. One of the translators reportedly, according to one of the detainees, raped a juvenile. These contractor interrogators were deeply implicated in the abuse. And the report by General Fein says that the contractors were supervising uniformed troops at the prison and concluded that the commingling of authority by contractors, other governmental actors, and troops contributed to an environment of confusion and lawlessness on the ground that led to the abuse. The use of contractors here at Abu Ghraib is really just the tip of the iceberg. It's part of a much broader phenomenon that we've seen in the military to privatize and outsource a broad range of functions. So we've outsourced many logistics functions. Private contractors are supplying meals, latrines, and so forth. We've also outsourced training, strategic planning, and in addition, many security functions. So private contractors are guarding convoys and ambassadors and various sites. And in addition, contractors are conducting interrogation and doing translation for those interrogations. And just to give you a little bit of data, there are about 100,000 contractors in Iraq right now. A ratio of contractors to troops that is beginning to approach 1-to-1. In the first Gulf War, the ratio was reportedly 1-to-10. So it's a huge increase. And of those contractors, about 25,000 reportedly, perhaps more, are security contractors of some kind. This raises very big questions about accountability. What happens when a contractor interrogator uses excessive force when questioning a detainee? Who can hold that contractor accountable? And I'd like to focus on 3 accountability mechanisms: criminal law, civil tort suits, and the government contracts themselves. So first, starting with the criminal law, the short answer is that it's not really a problem of law in the books at this point. It's a problem of the law in action. It's a problem of enforcement. International law does prohibit contractor abuses. There's a little bit of a gray area in some respect. So the Geneva Convention's prohibitions on use of force, both with respect to international and internal armed conflict, bind non-state actors. The Yugoslavia Tribunal has concluded in dicta that that there's no state action requirement. You don't have to be an official governmental actor in order for the prohibitions to apply. The Nuremberg tribunals convicted corporate managers for cruel treatment and other abuses during World War II. The Second Circuit has said there's no state action requirement for war crimes. I think there's a pretty good case that contractors would be held responsible under war crimes law. Torture is there's a bit more of a gray area there, because the definition of torture binds official actors. Now, those who are sufficiently connected with official actors would arguably fall within that prohibition, but there's some gray area there. But overall, I think the case is strong that both sets of international law prohibitions would bind contractors. With respect to domestic criminal law, U.S. criminal law would apply extraterritorially to places like Iraq where the interrogations are occurring. The Military Extraterritorial Jurisdiction Act subjects contractors who are working for the Department of Defense to federal criminal jurisdiction. Now, the problem with that statute is that it exempts anyone hired by another agency. And the contractors at Abu Ghraib were hired under an agreement with the Department of the Interior, an agreement with CACI, so they wouldn't be covered by that, and that's a significant gap. On the other hand, the Special Maritime and Territorial Jurisdiction would apply in most cases to the places where the interrogations are occurring. The USA Patriot Act amended it so that it would apply. So it's not really a problem of whether there is applicable law. The problem is enforcement. So far, we've only had one case brought, and we're very fortunate to have the lawyer who prosecuted that case here to talk about it. That's the prosecution of David Pissarro. There are reportedly numerous files on cases that have been investigated. Those files have been sent to the Eastern District of Virginia, but no action has been taken on those cases. So what's the solution? Well, one solution might be perhaps to set up a special office within the Department of Justice that is responsible for contractor investigation and prosecution. Perhaps that would facilitate prosecutions, enhance congressional oversight, because that office might report directly to Congress. That might be one possibility. Another possibility would be to prosecute contractor interrogators under the Uniform Code of Military Justice. And recently, Senator Lindsey Graham slipped a provision into the Defense Appropriations Act very quietly last year, which would extend the Uniform Code of Military Justice to civilians accompanying the forces in contingency operations, and not merely during declared wars. Therefore, contractors could be brought within military jurisdiction. Now, this obviously raises constitutional questions. in the 50s and 60s, the U.S. Supreme Court said that civilians could not ordinarily be tried in military courts for a variety of reasons. Those decisions might not hold up now. There's an argument that military trials under the Uniform Code of Military Justice have developed in such a way with protections for the rights of the accused and so forth that the same concerns present in the 50s and 60s are not present now. It's certainly an open question. One advantage that many have said to bringing contractors within UCMJ jurisdiction is that it would bring them more formally within the command authority of commanders on the ground who right now don't have the formal authority to order contractors to do anything. Formally, the contract monitor and the contract officer are the ones that hold the authority, which clearly poses a lot of problems in these kinds of situations. For more control than commentators regularly assert, under either the Alien Tort Statute or under ordinary tort law, there may be tools of remedy and control here. There's a pair of cases in the district court in DC that have been brought against Khaki and Titan, the firms that employ the contractors at Abu Ghraib. The alien tort claims got thrown out actually on state action grounds, but the tort claims are proceeding. Now, one of the big questions here is how far the government contractor immunity defense goes. In the past, it's been developed primarily in the procurement context when contractors were supplying goods and weapons and so forth. The question is whether contractors performing services that require a good deal of discretion would be subject to that immunity, and also whether when there are human rights involved, when there are intentional torts involved, whether that doctrine really ought to apply. That is an open question that the district court is going to resolve. The court did not dismiss the claim and is proceeding to address that question in detail, and has given signs that it's not going to just do a blanket application of the contractor immunity defense. So civil law might offer some control. Another place of accountability and control is something that's not often discussed or looked at in the literature, and that is the government contracts themselves. To what extent might these contracts be a tool of control? Now, I have looked at all of the publicly available contracts for activities in Iraq. It's about 60 contracts. And I have compared them to roughly analogous contracts in the domestic setting between state governments and entities performing functions like prison management, healthcare, and so on that might be roughly analogous and might have some interesting lessons to bear on this point. And what I've discovered is that there are some three areas that I think we can look at where the foreign affairs contracts could do much better. Contract can be a better tool. It is a better tool in the domestic setting. It could be used more here. What are the three areas? First, more specific terms. So the contracts themselves could resolve ambiguities about norms. So to the extent that there's a gray area about whether torture, the torture prohibition binds contractors, the contracts could make that specific. They do that in the domestic setting all the time. The contracts with the private prison operators specify that certain constitutional norms apply. There is a similar kind of gray area in the application of domestic rights protections because the Constitution binds state actors primarily. So the contracts themselves eliminate that ambiguity. You could do that here. You could specify, for example, the Army Field Manual should apply, and so on. This is not done in the current contracts. The khaki work orders say nothing on this level. They could be dramatically improved. Also, you could have specific training requirements embedded in the contracts. The khaki contracts are quite vague on this score, and it's probably not surprising that a governmental report concluded that 35% of the interrogators at Abu Ghraib prison had no training at all, let alone training in limits on the use of force. Training requirements could be much, much more specific. They are in the domestic context. Prison guards have to get training equivalent to that of official state actors performing similar jobs, which includes training on limits in the use of force. So in addition to specific terms, the contracts could also have much better monitoring and enforcement. We have an enormous monitoring and oversight problem in Iraq. At the same time that we've increased the number of contracts, we've cut the acquisitions workforce in half, and these monitors are not trained in limits on the use of force generally. They're focusing on fraud and waste. They don't have the expertise to monitor these situations, and they're the ones with the authority under the contracts. We need more monitors. They need to be better trained, and they need to actually go out and do their job. In a lot of cases, they're not even going to Iraq because they don't want to be on the ground in that security situation. So we need to revamp the entire monitoring situation. In addition, we need to look at approaches such as accreditation. In the domestic setting, private companies that perform functions like prison management and healthcare have to get accredited by independent organizations. Now, in the healthcare setting, there's an interesting analogy where an independent entity called the National Committee on Quality Assurance began to rate HMOs independently along various benchmarks of quality. Those ratings then got adopted within the state contracts for HMOs receiving public funds. They migrated into the contracts, and now in many states you have to be NCQA accredited before you'll get a contract. We could do this with respect to a whole range of contractors, but including in the intelligence and security area. Now, there's a nascent effort by an organization called the International Peace Operations Association to bring companies within its organization, get them to sign on to a code of conduct, and so forth. This is an industry group. They've done important work, but it's an industry group nonetheless, and I think there's a lot of room for other organizations to rate and provide benchmarks that could be then used by government entities awarding the contracts. Finally, enforcement. This is a huge issue because the contracts can only be enforced by the government and the contractor. And so one solution would be to allow for third-party beneficiary suits. I admit this is not realistic, and we don't even in the domestic setting have much third-party beneficiary suit enforcement. What we do have in the domestic setting, though, are very vigorous whistleblower protections and transparency rules. We need to improve those as they apply to these kinds of contractors. The False Claims Act has a whistleblower protection provision that applies to company employees who blow the whistle on fraud, but it doesn't extend to other kinds of abuses. So when DynCorp was training police officers in Bosnia and a number of employees got involved in a sex trafficking ring, an employee blew the whistle on them, a co-employee blew the whistle on them, she got fired. She had no protections under any statutory provisions. So we need to improve our whistleblower protections. And one other possibility that we might consider are some forms of privatized dispute resolution mechanisms. You know, in the prison setting, the private companies have to give prisoners who claim abuse some kind of proceeding. This is provided by the private company. We could argue that these companies ought to do the same thing. So, of course, the contractual reforms are just one piece of a much larger puzzle. We clearly do have an accountability gap here when it comes to the use of security contractors, interrogators, and translators. We need to think about how to improve oversight and control. Thank you very much.
Thanks, Laura. Now we'll hear from Jim.
You'll have to forgive me. Usually before I address anyone, there's a distinguished gentleman or a lady explaining to the audience that what I'm about to say is neither evidence or actually even logical or rational, but merely my musings upon the case that they have just spent a large amount of their time. I would like to thank the kind people at Duke Law, Professor Chesney, the Wickershams, for having me here. I'll ask your forgiveness ahead of time. This is the first time that I have discussed Pissarro. I intend it to be the only time that I discuss these aspects of Pissarro. Mr. Pissarro is currently appealing his conviction and sentence. I will be limited in some regard to my remarks on that. What I'm going to speak to you about are things that I have said on the record or things that have been said on the record regarding the case and things that would be pertinent to the investigation. I am amazed by the amount of interest that the case cultivated around the world. I am appreciative of that. But let me say this. My job as a prosecutor is simply that. As a prosecutor, when I believe a crime has been committed and that I believe we can form an investigation that will allow us to provide a jury with proof, evidence, beyond a reasonable doubt, that is my case. You must understand, from my perspective and the optic that I view these cases on, as a federal prosecutor, there are two types of cases that we primarily bring. There are the types of cases that are exclusive federal jurisdiction, a wire fraud, a mail fraud, a bank fraud, a bank robbery, the things that we encounter every day. There are photographs of the defendant perpetrating the crime. There's a photograph as he exits the bank, usually with a height meter right next to the door. There's a testimony of the teller. There are marked bills. There's a die pack. The cases are relatively uncomplicated and easy to prove. Then there are the other type of cases, and that's where Pissarro figures in. A case that is so compelling, a case that represents a statement of what criminal prosecutions are that need to be brought, regardless of the risk. You understand that the government, many times in the game of prosecution, is the house, the dealer, and also the opponent. I select the cases of which we bring. There are many times that I hear the criticisms that the judicial system could not possibly be fair or effective because we have a 99% conviction rate. I would tell you that you would have a 99% winning rate if you got to choose the cards that you chose to play every time you sat down at a table. That if you sat down and the dealer dealt you 2, 4, 7, and 9, and you say, I won't play this hand, I won't even put my money on the table, and you walk away. Then when he deals you 4 kings, you say, I'll sit down and I'll play these. You'll sit there too. That's the position government prosecutors are typically in. I'm not saying that to garner pity or to garner respect from you, but Pissarro was a different breed altogether. Let me give you a little bit of background upon the case. The case began with a phone call, a phone call that most cases begin with, a call that there's an investigation regarding an individual that's within the Eastern District, North Carolina, the 44 easternmost counties. Let me back up. That's who I am. I'm an assistant United States attorney who also happens to be the anti-terrorism point of contact. There are 93 of me in the country. We all have discrete areas. Mine happens to be the wonderful Eastern District, North Carolina, which you are not presently in at this point, despite any wranglings and my attempts to bring this beautiful place into that district. Typically, I am prosecuting and investigating terrorism-related offenses. Terrorism financing, terrorism money laundering, material support of terrorism. I'm also involved in a number of counterintelligence investigations in our unified attempts of bringing in the federal response to terrorism here domestically. This phone call came from the Central Intelligence Agency's Office of Inspector General. I had some background in a previous life. I had worked with the Internal Security Section as a senior trial attorney in Washington, D.C. Now that organization is referred to as the Counter-Espionage Section, and we prosecuted a series of national security cases. I had worked previously with the Office of Inspector General on an investigation of the former Director of Central Intelligence, John Deutsch. The call began quite simply. Someone has died. Someone has died who is in the United States custody. The investigators are dispatched. You're on standby. We want you in from the beginning on this. Who did the call come from? That's a fair question. Let me explain to you that on that day of that phone call, in many ways, I sat in the position that some of you would sit in here today, not being familiar with an interrogation program, not being familiar with the rules of engagement, and who we had prosecuting some parts of the war on terror. I made a quick study of it. I would like to thank some of the people in this room who have provided me an education in regards to that. Professor Silliman has kindly provided his time and counsel to me over the years, working not anywhere directly related to the facts of the case, but I would appear in his office periodically, close the door, and ask him a hypothetical question based on extraterritoriality and what problems would I have. I will tell you that as a prosecutor accustomed and quite happily convicting 99.5% of my cases, I believed when I heard the facts of this case that we had 4 eyewitnesses, not just any 4 eyewitnesses. As a prosecutor, oftentimes my witnesses are what you would call co-conspirators or convicted felons or paid informants. These people bring a significant amount of baggage to the investigation and to the stand. I see all the military prosecutors nodding their heads in understanding of this. In a previous life, before the previous life, I was a Navy JAG, and I always say that 90% of your stories are accomplished in 10% of your career, and that was my JAG experience, and I applaud you. What happened, though, in this case was a different type of baggage. Our 4 eyewitnesses were the guards. Let's stop there. David Pissarro was a CIA working on behalf of the Central Intelligence Agency in a contractual relationship. He was there and trained. He was previously a Special Forces medic. Now, make no distinction. Either you're Special Forces or you're not. His particular specialty in that group was that he was a Special Forces medic. an extremely high degree of training that he received in that field, and a very rigorous study of medicine and emergency trauma medicine. He, at the time, however, was a National Guard. He had left the Army, and he was participating with a National Guard group. And then he actually was employed by a civilian DOD component that worked with Special Forces here in Fayetteville, North Carolina. Mr. Pissarro was a former police officer for the city of Hartford who was fired because he assaulted another gentleman within the first year of his employment and was let go. Mr. Pissarro's job, as it came out in trial, was to train with local Afghan militia and in working in their response to terrorism there in Afghanistan. The place that he worked primarily was a base at Asadabad. Asadabad is a small town, or if you call a town, 5 to 10 miles from the border of Pakistan in what would be considered one of the most violent areas of Afghanistan. Asadabad, like many forward operating bases, was subjected to rocket attacks, and in the summer of 2003 was no exception. The base had been periodically rocketed, and just imagine a base in the valley, in the flat part, with mountains surrounding it, and a river on the other perimeter. The modality that was used were relatively low-tech, foreign-made rockets that were set on timers that were activated with the rising of the sun. And these would be placed remotely, and the perpetrator would be long gone after the rocket was done. The guidance system on the rocket, or the targeting of the rocket, was also extremely primitive. During the time Mr. Pissarro was there, in fact, no rockets had impacted upon the base. I don't wish to be trivial about rockets. I have a problem with small arms fire, much less a rocket going overhead. I only say this because it'll come in later and how we discuss this. An individual's name had surfaced amongst the group of Afghans and therefore U.S. authorities. That individual's name was Abdul Wali. Wali was a resident of a village that lived outside the town. Wali, having heard that his name was brought to the attention to some of the Americans, presented himself to the governor, the Faisal Akbar, and the governor encouraged him to present himself to the Americans and clear his name or explain this all. There was a previous incident where something also similar happened, and that person was eventually cleared. He did just that. He came to the base. Now here's a little footnote. As I have learned in my quick study of the history of Afghanistan, it is a tribal world with blood feuds that run back 300 years based on land, marriages, something out of a Shakespearean event. Names provided to then the Soviets, names provided to the Americans are often a way to vindicate a 100, 200-year-old blood feud over a piece of land that is next to a river. United States intelligence is aware of this and are very skeptical of the names that are brought forward initially and always seek corroboration. Wali believed that he was in fact his name was put forward by a rival tribe to exact some measure of revenge upon his family. Wali presented himself to the United States forces, and he was then detained for a period of 72 hours. During that time, Wally was understanding the base. The base had less than 200 inhabitants. I know the exact number. I'm not going to share it with you here. I know the exact numbers of groups of people that were there. I'm not going to share it with you here. Let's to say the base was roughly less than 500 square feet in an extremely violent part of the world, inhabited by less than 200 military and other personnel. During that time, there were components of the 82nd Airborne. The 82nd Airborne were tapped to serve as guards for Wally while he was questioned by the U.S. forces. Dave Pissarro volunteered at a time to question Wally. Now, I bring this up because the guards were people that you would describe, or I would describe, I don't know how you would describe them, but I have the microphone so I can describe them, as relatively inexperienced, unskilled, other than mortarmen. They would operate mortars, and they were used there to guard Wally. They were active duty Army, all between the ages, I would say, of 20 to 24 years old, many of them on their first enlistment, certainly many of them the first time in a hostile land, and not being anywhere near, anywhere like Asadabad. I think that the reason that that's important is exactly what Professor Dickinson explained about, the confusion of authorities that can exist when we have a facility like Asadabad. I want to make a fine distinction here, and we can follow it up in a discussion. Simply because someone exerts supervision doesn't always necessarily mean that they are authorized supervisor. In our theory, David Pissarro had basically what we would call badged his way into a position of authority with the military, co-opting them. There were three challenges to the prosecution. One was the part of jurisdiction, of which Professor Silliman would have to hear my constant arguing and wrangling with. We were successful on that. We used the provision that Professor Dickinson spoke about in regards to the Patriot Act extraterritorial expansion, brought in there that it was in fact a U.S. facility overseas. The second part was what we had was the difficulties of the investigation and how we were able to bring together the resources of DOD, which this prosecution would never have been capable of doing unless the United States Army fully backed it. We brought literally witnesses in uniform from 3 different continents for different stages of the investigation, satellite secure telephone conferences, as well as for trial, and as well, if I'd be remiss, the full cooperation of the Central Intelligence Agency on prosecuting Mr. Pissarro. It was a pitched battle. I can tell you that the issues that we faced in the pretrial motions, Mr. Pissarro claimed a public authority defense. He was never capable of explaining who, in fact, had given him, well, let me back up. What a public authority defense is, a DEA cooperator working undercover would sell narcotics to another individual. What would be illegal for anyone else to do. If we grab that person in a law enforcement operation and charge them, that individual would be authorized to bring what is called a public authority defense. In other words, yes, I did distribute 15 grams of methamphetamine. However, it was provided to me by the DEA, Drug Enforcement Division, and I was authorized to distribute it. Mr. Pissarro claimed that he was, in fact, authorized to do this, even though he never articulated who had authorized him to do this. That was the other part. The other aspect of this was gray mail. Gray mail is typically brought in espionage prosecutions where the defendant tries to or threatens that they will seek and release classified information at trial, making it such a thorny porcupine that the government will back off and and not pursue prosecution of the individual any further. I can tell you that he stands convicted because we did not flinch in the eyes of that. We used the Classified Information Procedures Act to protect those secrets, to declassify documents, to provide him the discovery that he was in fact entitled to do. And the third part is the due diligence that we had to do as a prosecutor. He raised serious issues in regards to United States programs. I must make it clear from the trip that I have made, from where I began and where I am today, that that term of art, and for the purposes of this discussion, I think if we want to go forward, the term of art of interrogation, we must be very specific with what we define or how we define interrogation for this purposes, and who we define as interrogators. Mr. Pissarro was a contract paramilitary. He was not a trained or contract interrogator. I would say to you at this point that there are some things that, whether they are vital or so crucial, that they cannot be contracted out. And speaking from a personal standpoint, these issues of accountability and other types of things, and our ability to defend the actions of people who might be lawfully engaging these acts, or you may disagree not, it should not be outsourced. But Mr. Pissarro wasn't one. But understand this. Why are we interrogating? This is the dynamic that'll go for. Why are we interrogating? Why is Jack Bauer interrogating? Jack Bauer, he's interrogating because we need information. Information is intelligence. What is intelligence? How we get it is sources and methods. What is sources and methods about? Sources and methods is the very verification and the rationalization on why we classify things and protect things. You can see I'm building a circle. So if we begin with the point that we need this information and we need to question, and questioning and debriefing, as Dr. Fein said, it might be different things, then we come back there. The problem is, and this is why maybe criminal prosecutions are not a way to police this, is because it's an imperfect system. I have a beyond a reasonable doubt standard. If I asked you to manage your organization by criminal prosecutions and try to exact on a beyond the reasonable standard, you'd say, boy, that's not a very effective system. This system exists because of justice, because someone was victimized, and that because the rule of law stands firm. I thank you for this time to speak, and I thank the panel.
I was going to exercise the moderator's privilege to pose a series of questions, but I'd rather hear what you guys would like to talk about. So let's jump right in. Perhaps start with Steve.
This has been a wonderful panel. Thank you very much. I have a question for Dr. Fein. The French stopped torturing, they said, back in the 17th century. They started again in Algeria. The Brits stopped in the 18th century. Blackstone wrote about that. You mentioned the CIA manual from the 60s. And you also suggested that there's really no evidence that torture or coercive interrogation, no evidence that it produces valuable intelligence. If that's true, why are we doing this?
I would try to say three things. First, historically, at least as I understand it, quote, interrogation, extreme interrogation, torture, a word still I have a hard time defining or understanding, but it's certainly used a lot. Three purposes. One was, historically, to compel compliance of a civilian population. That is, we do terrible things to people and say, hey, if you don't fall in line, this is going to happen to you. A second has been to extract confessions from people. And a third has been to get information considered intelligence. When people talk about history of, quote, torture, they often fuse the three, as if we're talking in this context, at least I am, about how to get information that might be critical to preventing attacks, saving lives, in effect, intelligence, information. To try to be more precise, we could not find any government-funded or other studies about interrogation or about effectiveness. We did not look for studies of, quote, does torture work? Number one, couldn't figure out what torture means. Number two, it is ethically exceptionally difficult, if not impossible, to do a prospective study about we're going to do X to these people and not and see what it works. Those studies haven't been done. They won't be done. If one looks historically, and in a sense the best situation I can imagine from trying to learn, respond to that question, would be to look at the experiences of, for example, members of the armed services in the Vietnam era who were captured and held by the North Vietnamese, to whom awful things were done. There would be ways to do a kind of study to say, was there a relationship between the horrible things done to those members of the military who were captured and tortured and the information they gave out? It seems to me it's very important to make the distinction between compliance and giving out actual information. If you captured me and you did horrible things to me, my lips would move. I would tell you things. I would, quote, comply. If I knew the secrets to the nuclear code, even if you did horrible things, I might not tell you. People often don't distinguish between compliance, getting somebody's lips to move, and whether they are providing accurate and useful information. So I think we don't know. I'm not suggesting that anybody should, quote, do torture, whatever it is. But my general point is we have enormous amounts we can learn about how appropriately to interact with persons in custody for the purposes of gaining information that might help save lives, and that's an area that we need to professionalize, to think through with the kind of legal guidance. The one just final note on this, with great respect for my many friends who are attorneys and professors of law, the discussion in the U.S. over the last several years, it seems to me, has been fundamentally one of what should the rules be, what should the laws be, and very little about how do we actually engage appropriately in these kinds of activities. The Secretary of Defense group, for example, in 2003 that worked on this, and some of you may have been members of it, fundamentally, as I understand, had 70 attorneys. I'm sure each a wonderful person. But what do they actually know about the process of the experience that they're developing the rules for? How do we think to the future on this, the rules as well as the content of what we do?
So is the answer that we do it because we think it might work, in spite of lots of contrary evidence? Or are we doing it?
Fundamentally, I look at it that under very difficult circumstances, generally well-meaning people did the best that they knew how to do without there being a solid knowledge base about how to do this, because we had not, as a country, for the last 40 years, systematically thought about how to do this. And as of today, while there are individuals with great experience and I would say expertise, we still, if any, put it slightly differently, if any of your sons or daughters or nieces or nephews or grandchildren join government service in the next X years and are asked to interact with someone in custody who is believed from multiple sources to have information critical to national security, my hope would be we could provide them with the best possible knowledge base so that, consistent with the law and the rules and ethics and all that, they could do it most effectively. We have a long way to go to develop that kind of knowledge base, as far as I see it.
Deborah?
And thank you all also for a wonderful panel in all respects. This question is primarily for Mr. Candelmo and also to some extent Professor Dickinson, and it's really two questions. First, a really unfair one. Why haven't more prosecutions been brought? There were a number of cases, I think up to 20 referred by the CIA or other government agencies to the Department of Justice. As Professor Dickinson mentioned, those really haven't gone forward. To the extent you can talk about it, is this a structural problem? Is there a problem of the reach of the law, of gathering evidence, of making a case, or is this a problem of other considerations that are limiting these prosecutions? And the second piece of the question is, and this is a much kind of broader set of arguments that you hear a lot, to what extent, in your judgment, as somebody who generally prosecutes or has often prosecuted terrorism-related cases, is it so much of a challenge in these cases as opposed to other criminal prosecutions that you make that we should think about either special national security courts or other rules to handle terrorism cases? Are those things necessary? Is the justice system, the criminal justice system, currently adequate? And to what extent, in your judgment, do you think criminal justice process may interfere with intelligence gathering or other methods we might have? So with those completely unfair and very long questions, I welcome your response.
I think that's our next panel next year. I will, you asked the questions, the three questions I get asked a number of times, and why are there not more? I am not privy to those investigations. I share with you the challenges that I faced, and then if you can transfer those on. Gray mail, the ability to demand, discover some of our most sensitive national secrets. I was the prosecutor on United States versus Pissarro. If I told you I just showed up one day and asked them, could I please look into these programs to see if there's any merit to what the defendant is saying or claiming, they just said, welcome, come on in, let's show you everything that was a difficult issue for us in that way. I think the gray mail is a very difficult issue that we cannot overestimate. Jurisdiction is a very difficult issue for us to cross, and I don't, because we deal with this all the time, but it cannot be underestimated. The ability to prove something beyond a reasonable doubt. My ability to make sure the witnesses who are not U.S. nationals will be there for trial is greatly limited. If you rob a bank in eastern North Carolina and the tellers from Sampson County and the bank presidents from Duplin County, I can guarantee you that the United States Marshals are going to make sure my witnesses are there for trial. If you're talking about that you're in a remote village that's 20 miles outside a remote fire base that is 5 hours away from anything that you would consider civilization, that's a completely different animal, and I just want to make that really clear. I think the second point is, does the criminal justice system interfere? I think your remarks are, I think Professor Dickinson, I don't want to speak for her, but I think the reason why she has alternatives 2 and 3 for the contractor problem is because, number one, the criminal justice system was neither meant for that or not. And as far as changing a system, I'm not the thinker of big thoughts at this panel, but I will tell you that what Mr. Pissarro did was in a dark 12 by 12 cell in the shadows of the mountains of Afghanistan, where he thought no one would find him, where justice wouldn't seek him. That's where many the most despicable acts I have encountered as a prosecutor occur, and it's my firm belief that it's light that's the disinfectant of those things, and that a formal, open court system is the best way for us to preserve our democracy and defend the Constitution. So that's my personal opinion on that. I think you can kind of glean how I feel, how we need to address, and if there's any changes that need to be made to the justice system. And she has, I'm sure, much more to say.
Well, that was really, really interesting, and I don't have a really good answer. You know, I don't know the answer. That's why, you know, I think we need to look not only at the criminal justice model, but also at other possibilities. I am interested in this idea of having a designated office within DOJ. I don't know what the reaction is to that idea. And also, I think exploring whether UCMJ trials might be a possibility. I mean, despite you know, I think there's a case to be made that the constitutional concerns are not the same as when Reed versus Covert was decided, and that has to be worked out, what that would mean on the ground, whether that's really feasible as well as a policy matter. And then I think we have to look to the civil law and also to contract, because I don't.
Is everybody awake? Good.
Because of the limitations in the criminal justice model.
We have time for a very brief wrap-up. Dwight?
I have a very simple nuts and bolts question.
Wait for the...
Where was the venue for the trial and why?
See if you can do that thing with the mic again. It was in the Eastern District of North Carolina. The reason why is David Pissarro was a resident of the Eastern District of North Carolina. He also departed from the Eastern District of North Carolina for his overseas, and he was residing in the Eastern District of North Carolina at the time that we brought the charges.
Okay, we're going to go ahead and take a 15-minute break now. For those of you who still have questions, I'm sure that the panelists will be available for a few minutes during the break, and we'll return here for our second panel at 10:45.